Hello world, Natasha here. Get ready because today we are going to decrypt some legal jargon. And I'm going to warn you in advance, this one's going to be a doozy because today we are going to decrypt the concept indemnification. So, what does it mean when someone asks you to hold them harmless? Well, let's walk through this together. So, you're signing a contract, you scroll through the legal language, and then you hit a section about indemnification or being asked to hold harmless. And then your eyes glaze over. You skip to the signature line, cross your fingers, and hope for the best. Does this sound familiar? Well, you're not alone. Indemnification is one of those legal terms that shows up sounding super intimidating, and it's in contracts everywhere, from your gym membership to business agreements to even event tickets. So let's break this down, what the term actually means and why you should pay attention to it. And we're going to use language that doesn't require a law degree. So first, what is indemnification really? Well, at its core, this concept, indemnification, is a promise to protect someone else from financial loss. So when you agree to indemnify someone, you're essentially saying, hey, if you get into trouble because of something related to our agreement, I'll cover the costs. Think of it as like legal insurance. You're agreeing to be the insurance policy for the other person. So let's use this simple analogy. Okay, I like to call it the helpful friend. So imagine your friend asked to borrow your car to move some furniture. But before handing over the keys, you say, if you get a parking ticket or you damage someone else's property while using my car, you're going to pay for it, not me. So just keep that in mind. Well, that's basically indemnification. Your friend is agreeing to protect you from financial consequences that might arise from their use of your car. So in legal terms, you are the indemnity. You are the person being protected. Your friend is the indemnitor, the person providing the protection. And then the parking ticket or the property damage, those are the potential liabilities. I know that's a mouthful. But common places you'll see indemnification, like really important things to think about are your gym and fitness memberships, right? So when it says members agree to indemnify and hold harmless the gym for any injuries or accidents, what this actually means is that if you get hurt working out, you're not going to sue the gym. And if someone else gets hurt because of something you did, you cover the gym's legal costs. That's a pretty big deal, so you don't want to scroll over it. Think of event tickets and venues. So when it says attendee indemnifies the venue against any claims arising from the attendee's conduct, what this actually means is that if you cause trouble at the event and someone sues the venue, you're going to pay the legal bills. So don't start a bar fight or, start a fight at a venue. Not a good idea. What about contractor and service agreements? So when it says contractor shall indemnify client against any third-party claims, what that actually means is if the contractor's work causes problems that lead to lawsuits, the contractor will handle the legal costs, not you. Software and app terms also have this kind of clause. So when you see user indemnifies the company against claims related to the user's content or use of service, what that actually means is that if you post something that gets the company sued or if you use their services illegally, you'll protect the company from consequences. Rental agreements have this too. So if it says renter indemnifies the property owner against damages or injuries, what this actually means is that if someone gets hurt on the property because of something you did, you'll cover the owner's legal expenses. All right, so there are different types of indemnification, and now that we understand sort of the basics, we need to, talk about these different types that you really need to know about. So we have one-way versus mutual indemnification. So one-way indemnification, which is probably more common, is that's when only one party protects the other. So usually we have this in cases where the customer or the user protects the business. So with this example, you indemnify your wedding venue against claims related to your event. There's also mutual indemnification, and this is where both parties protect each other. This is a more balanced arrangement, but an example here would be like two businesses working together and each agree to cover the problems that they cause. Okay, now we have broad versus limited indemnification. So broad indemnification covers almost anything that can go wrong. This is higher risk for the person providing the indemnification. So for example, the contractor indemnifies the client against any and all claims. That's pretty broad, anything at all. Whereas limited indemnification, this only covers specific situations. And because that's the case, it's lower risk and, seen as more reasonable. So example would be where the contractor indemnifies the client against claims arising from the contractor's negligence, right? The contractor has to have kind of done something wrong or been negligent. Now, what does hold harmless mean? Well, hold harmless often appears alongside indemnification, and it means essentially the same thing. When you agree to hold someone harmless, you're promising not to sue them and to protect them from lawsuits by others. So, an example of this would be customer agrees to hold Jim harmless for any injuries sustained during workouts. This means you won't sue the gym if you get hurt. And if you somehow cause an injury to someone else who then sues the gym, well, you'll handle that lawsuit too. Let's talk about some red flags. So when indemnification goes just a little too far, because frankly, not all indemnification clauses are reasonable. So you need to watch out for certain warning signs. The first is overly broad language. So when you see something like customer indemnifies company against any and all claims regardless of cause, why is that bad? Well, you could end up paying for the company's own mistakes regardless of cause. That's a red flag for sure. Also, when you have no fault limitations. So think of something like you have to indemnify even if the other party was partially at fault. Well, why is that bad? Why would you want to take responsibility for problems you didn't entirely cause? That doesn't seem fair. Another red flag is unlimited financial exposure. Okay, so think about having no cap on how much you have to pay. Why is this bad? Well, because a single incident could result in a massive financial liability. So, often we want to see a cap of a certain dollar figure, a ceiling, so that you have some expectation of, how bad it could get, what the worst case scenario is. And then additionally, indemnification for intentional acts, that's a huge red flag. So think of you having to protect them even if they deliberately do something wrong, right? You're essentially giving them permission to be reckless at your expense. Not a good one. That's a red flag for sure. So indemnification is a big deal. And so really think about how to protect yourself. So here are some tips. First, please read before you sign. Don't just skip over indemnification clauses. They can have serious financial consequences. Also, look for reciprocity. So in business deals, try to negotiate mutual indemnification rather than one-way protection. Also, seek limitations. So push for indemnification that's limited to specific situations rather than that has words with any and all claims. That's not ideal. Check your insurance, okay? So make sure your personal or your business insurance covers indemnification obligations that you're taking on, right? You don't want to promise to indemnify and then have to go into your own pocket. Try and match your indemnification responsibilities with your insurance coverage. And then always get legal advice. So for significant contracts or just when you're in over your head, have a lawyer review indemnification clauses before you sign. It could be a big deal. All right, so now some questions to ask before agreeing to indemnify. Don't just automatically agree. First, what specific situations am I covering? Remember, the narrower the better. And then, is there a dollar limit on my exposure? Unlimited liability is super risky. So, is there a cap? And then, am I only responsible for my own actions? Remember, you shouldn't pay for the mistakes of others. Does my insurance cover this type of obligation? So, plan for your finances. And then, is this indemnification mutual? Because fair arrangements really go both ways. When indemnification makes sense is when you're in control. If you're controlling the activity or situation, it's reasonable to take responsibility for problems you cause. I mean, really, it's kind of the adult thing to do. Also, limited scope. If the indemnification only covers specific, predictable risks related to your actions, that's also thumbs up for sure. When you have insurance, if your insurance policy covers the types of claims you might have to handle, that's great because it's, important to think of where will this money come from? And then reciprocal arrangements, right? So if both parties are protecting each other, this creates balanced risk sharing, which is just really the fair thing to do. So there's some common misconceptions about indemnifications, and so we really need to flag the myth versus the reality. First, the myth being it's just standard legal language. The reality is that, it's pretty standard, but these clauses have real financial consequences, and they vary significantly between contracts. There's not a one-size-fit-all indemnification term. Another myth is that my insurance will automatically cover it. Many insurance policies exclude or limit coverage for contractual indemnification obligations, so please keep that in mind. Another myth is that, I'll never actually have to pay anything. Hate to break it to you, but indemnification claims, they do happen and they can be super expensive. And lastly, it only applies if I'm clearly at fault. No. Remember, broad indemnification clauses can make you responsible even when fault is unclear. So you really need to be careful there. The bottom line is that indemnification isn't mysterious legal jargon. It's a straightforward concept with potentially significant financial implications. So when you agree to indemnify someone, you're essentially agreeing to be their legal insurance policy for certain situations. And so the key is understanding what you're agreeing to before you sign. Reasonable indemnification clauses that are limited in scope and relate to your own actions can be super fair. But broad, unlimited indemnification that makes you responsible for everything that goes wrong is something to think twice about. So remember, every time you see indemnify, hold harmless, or similar language, stop and ask yourself, what am I potentially agreeing to pay for? And am I comfortable with that risk? Because understanding indemnification helps you make informed decisions about the contracts you sign and the financial risks you're willing to accept. And that's worth much more than a few moments of reading legal language. All right, guys, if you have any other legal or tech jargon you would like me to decrypt for you, please message me in the comments.